Hey guys, welcome to my channel. So today I'm with the story of Blake Lively and Justin Baldoni's legal feud. Guys, this is going really wild, okay? So there was a Zoom hearing in court on the 6th of March. Let's listen to the summary. Please remember to like, share, subscribe, and drop your thoughts on this post. Let's listen to it, guys.
Here's a summary of the Lively versus Baldoni court hearing today. In today's hearing focused on approving the AEO category of the protective order, meaning attorney eyes only category. AEO designation limits access to sensitive information to a party's legal counsel. AEO is the most restrictive level of protection. So Blake Lively's team was arguing that AEO is needed because there is sensitive information when it comes to marketing strategies, insinuating that these strategies and business plans would be considered trade secrets. They go on to say that some security measures could be leaked, such as medical records, and that third-party communications should be kept private in order to prevent any leaks of this information. And Baldoni's team is opposing the AEO category. They say that the protective order in place is enough to safeguard this information. And they go on to say that publicists and PR firms already publicize their clients' information, so there's no risk of these leaks that they're speaking of. Baldoni's team also argues that they need all evidence in order to properly represent themselves, and they don't want to go to court every time they need to challenge the AEO label. And Brian Friedman is arguing that Blake Lively's team is trying to gain unfair legal protections because of their celebrity status. He goes on to say that the law should be applied equally and that celebrities should not be having special treatment. One point that I love that Brian Friedman brought up was, why was Blake Lively's team fighting so hard for this secrecy? But at the same time, they are making these public allegations against Justin Baldoni, expect Baldoni to defend himself against. Therefore, if Baldoni is being accused of wrongdoing, they have all the right to have access to all the information, meaning relevant documents to fight these accusations fairly. Both sides also accused each other of leaking confidential information. Lively's team accused Baldoni's team of using media connections to leak sensitive information, and they say due to this leak, their clients are now facing security threats. They also mentioned that a billionaire, aka Steve Sarowitz, allegedly pledged $100 million to ruin Blake and Ryan's careers. Friedman goes on to say that celebrity status should not justify extra legal protection beyond the normal protection in cases. He also mentions how Blake's team has wrongly accused Justin Baldoni of running a smear campaign against Blake Lively, but in reality, he is just responding to what Blake's team is putting out there against him. Another great point that Brian Friedman made was that Blake Lively's team has introduced certain third-party names into the case when it suits them. Therefore, their request to protect certain information is a bit hypocritical. The judge listened to both of the sides' accusations, but he did remind them that the allegations need to be proven through proper legal proceedings. Lively's team also argued that private communications involving third parties, meaning celebrities or like high-profile industry figures, should not be made public, aka this is about Taylor Swift. They say that any mention of a high-profile individual, even if it's unrelated to the case, could be exploited for publicity. And the judge did question if this was too broad of a protection. But get this, Blake's team responded saying that they didn't want any private messages to be made as tabloid material. Oh, how about when you put out those private messages in the New York Times? The private messages, that one thing you did not even have a proper subpoena for, that you decided to cherry pick and put in a certain order and delete certain things to put out a certain narrative. And Friedman argued saying that Lively's team's legal filings already included third-party names, such as a Sony executive, which I'm assuming they're speaking about Angie Giannetti, again, showing that they are willing to exploit certain high-end professionals if it suits their case. And while the judge has yet to make a decision, he did make sure to let them know that the court follows strict transparency rules, meaning any document filed in court would be made public unless there's a really strong reason it shouldn't be. He also acknowledged that some information may warrant an AEO designation, especially when it comes to like medical records, security reason, third-party privacies. But he definitely seemed skeptical when it came to the AEO designation when it comes to like PR strategies and marketing strategies, because the judge questioned if these would actually be considered trade secrets like Lively's team said. And he did suggest a compromise. Basically, whoever wants that AEO designation has to prove as to why it's warranted. At the end of the hearing, he did acknowledge that he knows this case has gotten a lot of public interest, but they are going to be as fair as possible. I think Brian Friedman did an amazing job firing back, showing how Blake Lively's team were hypocritical and contradicting themselves. Also, when he flipped the smear campaign, he showed that it wasn't a smear campaign, it was Justin Baldoni defending himself. Personally, after listening to this hearing, I have a good feeling about this outcome, but I guess we shall wait and see.
All right, guys, I am fresh out of court. I told you I would be bringing you the goods right after court was over. It lasted about an hour and 33 minutes and some change. Some keywords you need to remember from this hearing. Trade secrets, the term trade secrets was said about too many times. Judge Lyman was like, what the fuck trade secrets are you talking about? I mean, he didn't use that exact language, but he pretty much was like, what are you talking about trade secrets? They tried their damnedest not to say Taylor Swift. It was as if like that was the name of the game. Use high PR value, high PR personnel, but do not say Taylor Swift, which is all they were trying to say. And then they try to accuse Justin Baldoni of having like unlimited funds, pretty much saying Steve Sorowitz is coming in $100 million to see dead bodies. Like, it was a mess. I'm like, okay, is Blake and Ryan broke? No. They kept trying to kiss the judge's ass, talking about, we know you're very seasoned and the judge is like, yeah, I know, what's up? Like, say what you're trying to say without kissing my ass. Get to the point. Everything that happened in this hearing, I cannot cover in a 1 to 2 minute video because I know you guys like to consume it very quickly. So again, I'm going to put a poll up here. If you want me to go live, play the recording, you can listen for yourself. We can talk about it on live. That's different. And we will have like an hour to do that. Want me to break it down in multiple videos and multiple pieces? Let me know. I'll do that too. I choose to do the live. It'll be around 2 p.m. and the recording is about an hour, 10 seconds. We can run through some of it. So the live would be about an hour. So if you guys want me to go live, let me know. I'm going to put the poll right up here or put in the comments, go live, we want to hear for ourselves. Okay, Brian Friedman did come in there and land a couple punches himself. But at the end of the day, Brian Friedman was making the argument that like, it's not my job to prove why you don't need a protective order. It's your job to prove why you need it. And pretty much your argument seems to be saying, because this case is about celebrities, third parties are also celebrities, they deserve different protections and different laws need to abide to them. They're like, yeah, there's things that could come out that could do irreparable harm to the third parties with high PR value. Say the name Taylor Swift. Like, don't be scared, just say it. Pretty much they were like a hypothetical, say Mr. Baldoni was texting a friend about something, but now when it comes out, it makes him look bad. Much what you're saying is there is not one single text message between Blake Lively to anybody really saying she was SH, but there probably a bunch of texts from her to other people trying to say that she was trying to set this man up, or she wasn't scared of him at all. All that to say, the judge did not make a ruling today. We'll probably hear from him. It could be later today. It could be next week. It could be, we don't know. But he did not decide on anything today. Again, if you guys want me to go live, let me know. But the attorney's eyes only protective order really seems to be targeted to protecting Taylor Swift, which we already knew that. Just hearing the lawyers ramble on about high PR value and like avoiding the name Taylor Swift was freaking hilarious to hear. And Brian Friedman did his job. He did what he was supposed to do. So again, let me know if you guys want me to go live.
So there was actually no rule in courts that day. And now names were not mentioned. Instead, they used PR, whatever. So one question is, are celebrities supposed to be treated specially, even in court? Because let's keep watching on, guys. Thank you.
This morning, the court held a Zoom hearing on the protective order of Blake Lively and Justin Baldoni's legal battle. Currently, there is a model protective order, but Blake Lively's side filed new documents trying to get an AEO, which is an attorney's eyes only protective order. If an AEO provision is granted, it will limit access to certain sensitive information so that only the attorneys involved in the case will be able to see it. So that means not only will the public not have access to it, but also parties involved in the case will not have access to it. Luckily, I was able to hear both sides argue this morning, and I have to say Blake Lively's team sounded pretty weak in my opinion. I have audio clips from the hearing and I can definitely share if you guys want that, but I can say that Blake Lively's attorney definitely struggled in the beginning. She was very long-winded. She said a lot without saying much of anything. And then Brian Friedman spoke, and I just feel like he spoke very confidently, very matter of fact. He was very informed, and I just wouldn't be surprised if the judge ends up agreeing with Brian Friedman. At one point, Judge Lehman told Blake Lively's attorney that if this case goes forward, a lot of this information is going to become public anyway. He also stated that there is a public interest in how this court is being used, and the court has to respect that. Blake Lively's attorney tried to say that this protective order, the AEO, would protect third parties, and that could be anybody from Taylor Swift or the 2 female witnesses that are on her side. Brian Friedman argued that the model order is sufficient to protect those parties, and he also said they are asking because there are people who are powerful in the industry, and then he said that there shouldn't be different laws that apply. He also said this isn't a situation where it's Apple versus Microsoft and we're trying to protect trade secrets. Blake Lively's attorney then tried to say that Mr. Friedman once used the AEO order when he was defending Quentin Tarantino. Brian Friedman responded saying that case involved trade secrets and screenplay pages from Pulp Fiction. He said it's a very different situation and the court knows AEO are typical, but in trade secret situations, not in situations like these. After both sides went back and forth with their arguments, the judge ultimately said that he's going to be ruling later, so I will let you guys know what happens from here.
So there's a lot of Taylor Swift, guys. Is she really involved in this? Um, like I said too, no rule should be with preference. You shouldn't treat people specially because you're celebrities. I'm also a celebrity too, lol. Let's keep watching, guys.
I'm so glad I saw this comment before I shared any audio clips. If there are any lawyers present, please let me know if it's illegal to share. I definitely came in 10 minutes late, so I didn't hear this warning. Not trying to get in trouble with the law. I can give you a little more information, especially about Blake Lively's attorney starting off, which I said she was very long-winded and she did stutter a lot. He started off by saying if information about third party is released, it could be damaging to their reputation and their privacy. The judge then asked her for an example and she said, I'm going to give you a complete hypothetical, which I don't think is a hypothetical because it's very normal for friends to do this. She said, hypothetically, let's say Justin Baldoni was speaking to a friend that is a high-profile individual and was telling them about something that happened on the set with our client. That would be relevant, but its value and its necessity to the case would be overshadowed by the fact that that person is a high profile individual. She said it would create a significant PR intrigue versus if he was just talking to a private anonymous person. But if Mr. Baldoni was talking to Mr. Sarowitz or if he was talking to other cast members, that's directly relevant to the case. She said there is a different type of relevance by nature of who the individuals are, and she said that it would be compared to the category of the types of communications we would suggest that would fall under this third protective category. I understand that I'm not a lawyer, I'm not a judge. Personally, I felt like that argument was weak, and the judge did ask if she had any other categories in mind. This is when she did stutter, and she was referencing other cases, and she said, you can imagine that there's a level of personal and intimate information that is particularly relevant because of who these people are, that in ordinary case, they wouldn't be subjected to an AEO, but it would be in here. Judge Lehman said to her, if Lively or Reynolds said something about what was going on set that was relevant to this case, I wouldn't imagine that that would be attorney's eyes only. Mr. Friedman should have the right to discuss that with his client. She responded by saying, I think it's too narrow to limit it to only third parties. And then she said, if there were communications of, I was at this event on this date, or if one of them had text another person saying, it was great to see you last night, they get photographed out all the time, and it wouldn't be hard to put two and two together to figure out who they were with. Again, I feel like that was another weak argument, but the judge reminded her of the current protective order, saying that the protective order doesn't just apply to the lawyers, but also to the parties, and there's separate documents that people have to sign to get access to confidential information that binds them to the protective order, which means they can be held liable to contempt if they violate it. So why wouldn't that be sufficient? My orders are clear. If they violate it, they'll be held in contempt, and I'm very comfortable having a contempt hearing. She argued, though, that contempt hearings take a while to happen. She then goes on to say that there are health and mental health records that just have no business being released, and I would suggest that this is an entirely different case. She then goes on to say that there are 100 million reasons for these parties to leak information because the PR value is greater than complying with the court's order, and I don't think sanctions would be appropriate. And that's when Judge Lehman had told her that if this case continues or goes to trial, it's going to be made public anyway, and she said it's not in our ultimate interest to prevent the public from seeing all the evidence. That is, of course, what will end up happening here. But we think with highly sensitive materials, especially with third parties, we think it makes sense for there to be an AEO category, which is standard in cases. And Judge Lehman basically tells her, if you designate stuff that's AEO and Brian Friedman wants to discuss these things with his clients and he thinks it's overbroad, I'm going to have to deal with that. So I'm not sure how convincing relieving the burden of the court or of the parties this is. Now, this exchange was only about 10 minutes and I had summarized everything else in the last video, but I will let you guys know what Judge Lehman decides when he does.
We've listened to what was said, we've listened, and so we know, yeah, she was just trying to make her way through so she just gets what she wants, okay? So guys, tell me what you think about this. Remember to like, share, and subscribe to my channel, guys. Thank you. Bye.